Welcome to the Deep Dive, your shortcut to crucial commercial knowledge. Today, we're wrestling with something that seems simple, but wow, it gets complicated fast. We're talking about modifying a written sales contract under the UCC. When do those changes actually stick, legally speaking? And when do they just, poof, disappear?
Exactly. It's a classic clash between, everyday business practice and the strict rules of law. We're going to use Costco Wholesale Corporation v. Worldwide Licensing Corporation as our guide. It really shows how a simple price adjustment, like a rebate, can get tangled up in the statute of frauds and, crucially, questions about who actually had the authority to agree to the change.
Okay, let's unpack this. Our mission today is to get a clear handle on how the UCC deals with these modifications. And it seems like there are two big hurdles we need to jump. First, understanding the rules. That's UCC sections 2201 and 2209, subsection 3. Specifically, when does an oral change need to be put in writing? And second, maybe even more interesting, even if the statute of frauds is okay, did the person who made the change actually have the power to bind their company?
That's the path. It has to be systematic. First step. Is the modification itself enforceable? We look at the statute of frauds rules, paying really close attention to quantity. That's often the tripwire. Only after we figure out if the terms are potentially valid do we pivot. We ask that second critical question. Was the principal of the company actually bound by the agent who signed off on the deal?
Okay, let's kick things off with the basic UCC rule for modification. We have a written contract, sale of goods over $500, standard stuff. Now, we orally agree to change something, maybe the price, maybe the delivery date. How do we know if that oral change needs its own separate written proof?
The general rule is in UCC section 2209, subsection 3, and it says the requirements of the statute of fraud section, that's 2201, they must be satisfied if the contract as modified falls within its provisions. Now, that doesn't automatically mean you need a new piece of paper for every single tweak, but it does mean we have to look at the whole agreement, the modified version, and see if it triggers the statute of frauds. Usually that means, is it still for goods worth $500 or more?
Right. To see how this plays out, let's dive into Costco v. Worldwide Licensing. Can you lay out the essential facts for us? What happened here?
Sure. So the original deal was clear. 5 pallets of jewelry. The price was significant, almost $75,000. So definitely over the $500 threshold. Later on, Costco, well, they weren't happy with how the jewelry was selling. So Worldwide's agent, a guy named Lauren Coleman, he signs this rebate form, gives Costco back $16,640. But here's the twist. Worldwide said, hold on, Coleman only had the actual authority to give that rebate if Costco made an oral promise right then and there to buy 3 more pallets of jewelry.
Yeah.
Costco never ordered those extra pallets. So Worldwide refused to pay the rebate.
Okay, so that sets up the conflict nicely. What was the precise legal issue concerning the statute of frauds in this mess?
It was really twofold. First, did the statute of frauds just flat out invalidate the written rebate document itself?
Yeah.
Because it was modification. And second, maybe the trickier part. Could Worldwide use Costco's alleged oral promise to buy those extra 3 pallets as part of the deal? Could they use it as a defense, basically saying the rebate was contingent on something that wasn't enforceable?
Got it. So what rule of law did the court pull out to decide whether these modifications were enforceable, especially that idea of the original writing maybe being enough?
The court applied a really important two-part rule here, derived from 2209(3) and 2201. First part, if the original contract satisfied the statute of frauds, it was written, signed, had a quantity, that satisfaction passes through to later modifications of non-quantity terms, like price. But, and this is the critical second part, UCC section 2201, subsection 1 puts a hard limit on this. It says the contract isn't enforceable beyond the quantity of goods shown in the writing. So you have these two elements working together. One, the pass-through doctrine. Original so far as satisfaction covers later changes to things like price or warranties. No new writing needed just for those. 2, the quantity bar. But enforcement, whether you're suing or defending, is absolutely capped by the quantity stated in the original signed writing.
Okay, this is where we need to break down the court's elemental analysis. Let's walk through it step by step. How did the court apply the first element, the pass-through doctrine, to that $16,640 price rebate?
Right. The court looked at the original contract for 5 pallets. Clearly written, signed, quantity stated, over $500. So it satisfied the statute of frauds. Then they looked at the rebate. What is it? It's fundamentally a price modification. It changes the effective price Costco paid. Applying the pass-through doctrine, the court said because the original contract satisfied the SO and MF, that satisfaction sort of infuses the contract as modified. The price change itself didn't need a separate new writing signed by Worldwide to be potentially enforceable. So the rebate claim, on its own, wasn't barred by the statute of frauds.
Understood. Now, the crucial part, what about the second element, the quantity bar? How did the court apply that to Worldwide's defense? The defense that relied on the oral promise for 3 additional pallets.
This is where the rule bites. The original signed writing clearly stated a quantity, 5 pallets. That was the only quantity memorialized according to SOAF requirements. Worldwide's defense depended on proving an oral agreement to increase that quantity to 8 pallets, 5 plus 3. The court applied the quantity bar from 2201 directly. Since the statute limits enforcement only up to the quantity shown in the writing, the alleged oral agreement for the 3 extra pallets was simply unenforceable, period. It didn't matter that the original contract satisfied the SOAF. That pass-through doesn't work for quantity increases. Worldwide couldn't use that unenforceable oral promise as a shield or a sword. It was legally invisible for enforcement purposes.
So the quantity in the writing is like a concrete ceiling. You can't enforce anything above it based on just talk. What was the court's final conclusion then on Worldwide's statute of frauds defense?
The conclusion was that Worldwide's statute of frauds defense failed completely. They couldn't defeat the rebate claim by arguing Costco broke an oral promise to buy more jewelry, because that specific oral promise, the quantity increase, was rendered unenforceable by the quantity bar in the statute of frauds. The SOA's defense was struck down. #visceral hypothetical, illustrating the quantity bar.
Okay, so this quantity bar is serious business. Let's make this really concrete for you listening. Imagine this. You have a solid written contract. You're selling 100 custom-made widgets. Signed, sealed, delivered. Well, not delivered yet. Then your material costs spike. You call the buyer, explain the situation, and they orally agree, okay, we'll pay $10 more per widget. Does that oral agreement hold up?
Yes, most likely it does. That's a price modification. The original contract satisfied the statute of fraud, so under the pass-through doctrine, that oral price change is generally enforceable. No new writing needed just for that.
Okay, scenario 2. Same widget contract for 100. You call the buyer and say, hey, we can ramp up production, want 200 instead. And buyer says, great, yes, send 200. All oral. What's the immediate result there?
Dead on arrival. The oral agreement for the extra 100 widgets is unenforceable because of the quantity bar. The only quantity the court will enforce is the 100 widgets specified in the original writing. It doesn't matter how clear the oral promise was. To make the deal for 200 enforceable, you needed a new writing, signed by the buyer, stating the quantity is 200. Quantity changes require written proof under the UCC. It's that rigid.
That distinction is crystal clear. Price is flexible, quantity needs writing. But, okay, back to Costco. Worldwide lost the statute of frauds argument. But that didn't mean Costco automatically got their rebate, right? Worldwide had a second line of defense, agency. They argued their agent, Coleman the broker, didn't actually have the authority to give the rebate without getting the commitment for the extra pallets. So, generally, what kind of authority does an agent need to bind their principal, their company, to a significant contract modification like this?
Right, this is crucial. The statute of frauds is about enforceability, but agency is about whether a contract was formed at all. The agent needs one of 2 types of authority. Either actual authority, which is the power the principal specifically gives the agent, explicitly or implicitly, or apparent authority. Apparent authority is different. It arises from the principal's manifestations. There are words or actions that lead a third party, like Costco here, to reasonably believe the agent had authority, even if, secretly, the principal told the agent not to do it. The focus is always on what the principal communicates to the outside world.
Okay, let's apply this. Using the facts again, did the agent, Coleman, have actual authority to grant that $16,640 rebate unconditionally?
Well, if we look at the evidence in the light most favorable to Worldwide, which you have to do at the summary judgment stage, the answer is likely no. Worldwide's president, a Mr. Dose, testified he only authorized Coleman to grant the rebate if Coleman secured Costco's binding promise for the 3 additional pallets. Since Coleman signed the rebate form without getting an enforceable promise for those extra pallets, because as we saw, the oral promise was barred by the SOA, he arguably exceeded his specific instructions. So no actual authority for the unconditional rebate.
Makes sense. He didn't fulfill the condition the boss set. But that brings us to the really common issue in these disputes. Apparent authority. What did Costco need to show? What kind of manifestation did Worldwide, the principal, have to make for Costco to reasonably believe Coleman could just grant a 22% refund on his own?
Yeah, this is the heart of the agency issue here. For apparent authority, Costco had to point to actions by Worldwide that put Coleman in a position where a reasonable business person would think he had this kind of power. What were the potential manifestations? Well, Worldwide did appoint Coleman as the broker for the original sale. That's one thing. And they did authorize him to negotiate some kind of compromise when Costco expressed dissatisfaction. That's another. The question is, did those actions reasonably suggest he could give away nearly a quarter of the contract value?
Okay, so how did the court analyze those facts? Did appointing him as a broker and letting him negotiate give him apparent authority for such a huge refund? What about business custom?
The court found the evidence, well, lacking. It wasn't enough to grant summary judgment for Costco. Costco's own representative admitted they didn't rely on any specific spoken words from Worldwide's management confirming Coleman had this specific authority. More importantly, the court emphasized there wasn't enough evidence in the record about general business custom. Does a typical broker in that industry usually have the power to settle a major warranty or satisfaction dispute by agreeing to such a substantial refund, 22%? The court suggested, citing some other cases, that this kind of authority for such a large concession usually isn't assumed. It's beyond the scope of a typical broker's role unless the principle specifically indicates otherwise.
So the evidence just wasn't strong enough to say for sure, as a matter of law, that he had that power. What was the court's final conclusion on the agency issue?
Because the evidence on apparent authority was inconclusive specifically, whether Worldwide's actions and general business custom made it reasonable for Costco to assume Coleman had this power, the court reversed the summary judgment that had been granted to Costco. It wasn't that Costco lost necessarily, but there was a genuine issue of material fact about whether Coleman possessed apparent authority. That question had to be decided by a jury or judge at a full trial, not just on the papers.
Okay, now we get to what I think is the most fascinating, almost paradoxical part of this whole case. And this is where, you can really impress on an exam or in practice. Let's recap. Worldwide was barred by the statute of frauds from enforcing Costco's oral promise to buy the extra 3 pallets. That promise was legally invisible for enforcement. Yet then, the court allowed Worldwide to use evidence of that very same unenforceable oral promise to argue that their agent, Coleman, lacked authority. How can an unenforceable promise still be used as evidence like that?
It's a fantastic point, and it highlights a critical legal distinction. The statute of frauds only prohibits the judicial enforcement of certain promises if they aren't written down. It makes them unenforceable as contractual obligations. But Worldwide wasn't trying to enforce the promise here. They weren't asking the court to make Costco buy the pallets. They knew they couldn't do that. Instead, they were using the fact that the deal supposedly included this oral condition, buy 3 pallets, as evidence relevant to a different issue, the scope of Coleman's actual authority. They were basically saying, look, the deal Coleman was supposed to make included this condition. Since he didn't get an enforceable version of that condition, he went outside the bounds of the authority we actually gave him. Therefore, the rebate agreement he signed isn't binding on us. End quote. Using the existence of the oral term as evidence to prove the agent lacked authority doesn't violate the statute of frauds prohibition on enforcing the term itself. It's about proving the conditions under which the agent was allowed to act.
Wow, okay, so the term is dead for enforcement, but its ghost can still come back to haunt the deal by showing the agent went rogue.
That's a great way to put it. The promise itself can't be enforced as a promise, but the fact that the promise was allegedly part of the agent's instructions is still relevant evidence for determining if the agent had the power to make the deal they actually made. #tag diagnostic checklist synthesis. All right, this case gives us a lot to work with. To make it really practical for you, let's synthesize everything into a step-by-step diagnostic checklist. If you're analyzing a UCC sales modification issue, maybe on an exam, maybe in practice, here's how you should approach it. Step 1. So 2F trigger check. First things first. Is the underlying contract for the sale of goods $500 or more? If yes, the statute of frauds is definitely in play. If no, you can mostly ignore SUFF for modification. Step 2. Modification SUF check. Assuming the answer to step 1 is yes, does the contract as modified still meet that $500 threshold? Usually it will, but technically you check the whole deal as it stands after the change. If yes, proceed. Step 3. Quantity change check. The bar. This is critical. Does the modification attempt to change the quantity term? If yes, that quantity change absolutely must be in a writing signed by the party you're trying to enforce it against. Remember, enforcement is strictly limited to the quantity in an existing signed writing. Oral quantity changes. Unenforceable. Step 4. Price term change check. The pass-through. If the modification only changes non-quantity terms, price, delivery details, warranties, things like that, and the original contract satisfied the SOF, then the original writing satisfaction usually passes through. No new signed writing is typically required just for these kinds of changes under 2209. Step 5. Agency check. Okay, let's say the modification survives the statute of frauds analysis, either via pass-through or a new writing. You're not done. You must ask, did the agent who agreed to the modification have the necessary authority? Was it actual authority or apparent authority? Especially with special agents like brokers, look carefully for manifestations by the principal, not the agent, and whether the third party's reliance on things like business custom was reasonable.
That's an excellent roadmap. It really forces you to separate the statute of frauds enforceability question from the agency authority question, even though, as we saw, they can interact in tricky ways with the evidence. So let's try to boil down the key takeaways here. The UCC tries to be practical for business, right? It gives you that pass-through shortcut for oral changes on things like price, saves some paperwork. But the moment you touch quantity, the UCC draws a hard line in the sand. Quantity needs writing. Full stop.
Absolutely. And the agency point is just as vital. Who has the power to make changes?
Yeah.
It all comes back to what the principal of the company leads the other side to reasonably believe. Apparent authority is based on the principal's signals, not the agent's bluster.
Which brings us to our final provocative thought for you to ponder. We just established that the statute of frauds can make an oral term completely unenforceable, like that promise for extra pallets. So if you know an oral condition can't be enforced, why is it still absolutely critical to clearly document, maybe internally or even in writing to your agent, the precise limits of their authority, especially when their authority is contingent on getting something specific?
Because, as Costco shows, even if that oral contingency is unenforceable as a contract term, the fact that it was a required condition for the agent's authority can still be used as evidence. Evidence to show the agent exceeded their mandate.
And that could blow up the entire modification, even the parts that are in writing and otherwise look perfectly valid.
Precisely. Don't let the ghost of an unenforceable promise kill your otherwise valid written deal by proving your agent went off script. Document those limits.
Excellent point. A lot to think about there. That's all for this deep dive. We'll see you next time.